Hi everyone, I'm immigration lawyer John Khosravi. Thank you for joining us March 3rd, 2021. We're doing our Wednesday 5 p.m. Pacific live show that we do every Wednesday for a year now, or if not longer, since the pandemic started, taking your immigration questions for general knowledge, education kind of stuff, and trying our best to give some answers, some guidance, and some, just general ideas of how this U.S. immigration system works. I know it's really complicated and a lot of people have problems with it. That's what we're here for. Now, President Biden has come, and people are happy about that. And there's talk about immigration changes, but in reality, nothing really practically has happened that should make a difference in anyone's case. Even though they've made some big stuff, they said they announced some stuff, and one or two proclamations, executive orders are done. Those don't practically affect that many cases. So the reality is everything is still the same as it was during President Trump for the most part. But we have hope that things are going to get better. So please send us your questions right now so we get started. So we got a question. Official Rajan says, is the green card spouse interview banned? Well, it's not banned per se. It kind of is the same thing as a fiancé visa. First of all, the COVID-19, one of the bans for COVID-19, immigrant visa ban, that was changed. So spouses of green card holders were banned essentially from having their interviews, but that has changed. That's opened up unless you are in China, visited China, Iran, Brazil, Europe, and those kind of places. However, a lot of the embassies are either closed or partially staffed. So even though the ban on this is done, it doesn't mean that they're going to do an interview or get your case started immediately or anything like that. Practically speaking, no change is going to happen for the immediate period. I've contacted a lot of embassies, say, hey, what's going on? As soon as the ban went away, we get auto responses that say we're not even handling cases, we're not processing cases. Now, if you really want to push the issue, you could file a lawsuit, and I've seen that. I have cases where we filed lawsuits and they were able to get the embassy interview. But barring that, they're kind of slowly moving towards things, and it's not clear when it's actually going to open up. So our spouse of green card case banned? Practically speaking, yes, but legally, no. But even if it's legally not banned, practically speaking, nothing's moving forward. So that's the situation that we're stuck in. Neil Patel says, why conditions removal is moving so slowly? So when you are married and you get a green card like that, and the green card is relatively new, after 2 years, you have to file for removal of conditions. And removal of conditions, Form I-751, has for the last 5 or 6 years taken forever. Why is it? Because USCIS does not give it a priority. In their opinion, a person that's filed for removal of conditions has a green card, they had a work permit, they could request evidence of residency, and they could travel. So they say, of all this stuff we need to do, you have the lowest priority, which is, I think, incorrect. But nonetheless, what I think doesn't matter. It's what they want to do. Unless you want to file lawsuits or go to court or to contact Congress people, do what you got to do. So they don't give that much attention to Form I-751 removal conditions. And that's why on average these cases take 18 months. I have them done a year, I have them done 2 years, but on average 18 months. I've seen it longer than 2 years as well. I've got a couple done in 10 or 11 months recently, but that's not a consistent thing. I wouldn't say expect that. We just got lucky. But that's the situation in Form I-751. USCIS does not see it as a priority. That reason why I know is there's a report called the Ombudsman's Report. Every 2 years or so they release it. I was reading it. I have a different channel called the Immigration Lawyers Toolbox. I was analyzing the Ombudsman's Report for other lawyers. If you listen to that, it's a long, hour-long thing. It's technical. I'm not sure you'll find it fun or interesting. But if you listen to that, I cite the page where the Ombudsman interviewing USCIS, and USCIS told them we have naturalization as a priority, and so because that's important, but we don't have removal conditions as a priority, and that's why that takes longer. Can green card holders stuck outside the U.S. for more than 1 year due to COVID come back? You're welcome, Neil Patel. This question about people being absent from the U.S. and wanting to come back is a serious one. If you're outside the United States for more than 1 year, you could be considered to abandon your green card and potentially have your green card taken away. Typically, if the green card is still valid, I normally recommend clients just fly back to the United States as soon as possible. That's on a case-by-case basis. I can't give you that advice here because I don't know the people watching this, but this is, if I have an individual client and we're talking, usually that's the place I come out to. Or, if needed, you can file for an SB1 visa, a returning resident visa. Again, I don't like doing that, but sometimes we have to do that. Now, one thing that's popped up is some airlines will call and check your travel history, and if you've been outside for more than 1 year, they won't let you on the plane. I think that's crazy. You should try contact a different airline, but that problem does come up. It is possible. All people come all the time with outside for more than 1 year, especially under circumstances of COVID. But it really depends on which airline you're dealing with, which immigration officer you're dealing with, what your total life history is. Have you been frequently outside for more than a year, or is this that you got stuck? What proof we have of evidence? And that's why case-by-case analysis is required for this kind of stuff. I can't just say carte blanche, a blanket statement that it's okay. Under circumstances, and generally they're usually not too strict, but it always depends on the specific case and the specific officer that you're dealing with. Jen asks, hi, I'm in the US, my kids are not. Can my US spouse still file for us together at the same time? They can start the process at the same time, but if you're here, your process will happen in one scale in the United States, and then the kids will happen separately. So it's possible, but they're not all going to get the green cards at the same time. So that's something we got to sit and talk about and see what the situation in your case is, why this happened, how to time it, because you're going to be separated from, if you're in the United States and your U.S. citizen spouse applies for you, you cannot leave the United States until you get special travel permission. And that means you're going to be stuck away from your kids for maybe 6 months, 9 months, a year. And I don't want you to do that. So we really got to plan to see what's appropriate for your family. And that's why, first of all, download the Ultimate Marriage Green Card Guide at www.marriageimmigrationlaw.com to get a better understanding of what's going on. But then schedule a private consultation. How long can an advanced parole holder with work permit stay outside the U.S.? Somebody says only 3 months. Is it true? If you have advanced parole, there's no time limit per se of how long you could be outside the United States. You just have to be back before the advanced parole expires. So if you have 9 months of parole, there's no residency requirement timelines on advanced parole. It's just you got to be back before it expires. And then there's the question of, let's say, how did you get advanced parole in the first place? Was it based on marriage? They make questions and say, hey, how come you've been away from your spouse for 9 months? That doesn't make sense, because say, well, I need to work. I had a family situation back home. There's all these different needs. You have to have a reason. And that's why we kind of get into it, just in case they want to question you. But there is no timeline on advanced parole other than the period of time granted on the advanced parole permission, either the sheet they gave you or the EAD permit that has it. Jenks Kabul asks, can I file my I-130 first and file for the work permit after? The work permit could only be filed once you file for I-485. So I-130 is completely unrelated to the work permit. It does not lead to a work permit by itself. So you can file your I-130 whenever you want. It's when you file your adjustment of status from I-485 is when you could file a work permit request. And it doesn't make sense for you not to file it with it. I don't know a scenario what I can't say I guarantee 100%, but yeah, when you file for adjustment of status, you generally want to file for work permit too. There's some nuanced cases you might not want to because you've had a previous work permit. It goes into some technicalities. This is just general education, so I'm not going to jump down that rabbit hole. But yeah, your question, Jen, is kind of off because you can't get a work permit based on I-130. They're completely unrelated. So there might be more to it, what your question is, so we'll see what's happening about that. Just in general, the immigration situation is complicated because, listen, you want to file for a green card in the United States, you got to file I-130, maybe I-130A, I-485, I-131, I-765, I-864, I-944. You might want to throw a G-1145 there to get you get communications. You might have a the credit card application. I don't pay immigration fees by credit card. I've had those not go through and mistakes by USCIS, so I always send a check. But there's just so many forms. You might have 245I, you need I-485A. You might be employment-based, and I-485J, which is I-140 based. Yeah, as you can see, these numbers are jumping around the place. So that's what makes it really hard to be answered these kind of things without having a full sit down. But if you are doing a family-based case, especially marriage case, the Ultimate Marriage Green Card Guide has a good breakdown of how these forms go together and work together. Even if you're not doing a marriage case, if you're doing a family case in general, the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com should be able to answer and guide you in a lot of these things as to how it all works. So that's immigration in a nutshell. Thank you so much. Can I be a state citizen because it's illegal in my home country to be a dual citizen? Well, U.S. does not have any issue with dual citizenship, so you could be a U.S. citizen, a citizen of any other country, but other countries may not allow it. So I've done videos on this with regards to if you're from China, if you're from India, Japan, Germany, these countries do not allow dual citizenship. So once you become a U.S. citizen, you lose that citizenship. You got to find a workaround or whatever that country system has. India has some sort of special residency, old resident, previous residence, previous citizen program. You got to find out what that is. But that's a situation, so you got to make a choice. Do you want to be a U.S. citizen or keep your old citizenship? And with a green card, that's a personal decision that you're going to have to make. Is triple citizenship allowed in the United States? So we have the question about dual citizenship. Is triple citizenship allowed? Yes, there are people who are like Australian, English, Canadian, and U.S. citizens. Now, there are some regulations that could be interpreted as not allowing that, but the U.S., from my knowledge, has never hassled anyone about having dual, triple, or quadruple citizenship, so it hasn't been an issue. So, you know, I've triple citizenship, I've seen a lot, so I haven't had any worries, but, you know, you never know. They can always change the rules tomorrow. Matador asks, can Biden change the consular process for U.S. citizen couples? I mean, to change the consular process is just such a wide question. It's like, what part of it? There's no real need to change the process for couples. So, I mean, they're just working out. So there's nothing that needs to change. Right now with COVID-19, there's a health scare. So yeah, you could tell them, you know, screw it, you have to go to work. But, you know, it's an employment issue. It's like, do you want people to go to work? If there's a lot of COVID-19, they're scared or one person gets it. So that's the bigger issue. What I would like change, in particular with U.S. citizen cases, is twofold. If you are, I mean, it's hard to change this because they need more money and more bureaucracy, more employees to do it, but they should give more priority to spouse of U.S. citizen cases so they get done faster. So they need more money, more training, more funding. Okay, that's that. Secondly, technically you have to have Congress make up this rule, so it's an official law, but presidents make up laws all the time, so he could probably do it. President Biden could do it. Is this: if you're married to a U.S. citizen, you could get a tourist visa strictly to come to the U.S. to file for a green card. Right now, to do that, you're not allowed to come to the United States with the intent to file for a green card, but they should make a rule that says, yeah, if you are married to a U.S. citizen, we'll give an exception. You can use a tourist visa to directly come to the United States to be with your spouse and apply for a green card here. Right now, technically, it's fraud if you use a tourist visa to come to get a green card in the United States. But if you are already married, I wish you would do that. That's something you probably could pull off. That's on my goodie list that could happen. So U.S. citizen spouses are not staying separate for such a long period of time. It's a really nasty thing for that to happen. It's an interesting question, Matador. Thank you for asking that. So yes, you can change that. So what happened is, if you allow people to come on tourist visas when they're married to U.S. citizens to get a green card here, they'll just completely bypass the consular processing section that you're asking about. So it wouldn't be changing the consular processing. It would just be complete, just getting them out of the way. And that first thing I talked about, hiring more employees, well, that's in USCIS. So that's so the I-130 to be approved faster. Or Trump got rid of this, allowed direct filing of I-130s at international USCIS field offices or with the embassy. So we just bypass USCIS, the embassy has more staff, hopefully they'll hire more, and you just do the whole process there, which could take half as much time as they used to when people file directly. There are requirements that forbid it for a lot of people, but there are ways to fix this. A lot of it has to do with more funding and more training and more employees. This is not an easy thing to do, and so it's very difficult to do. But the one thing he could probably on a short pen do, it's not technically. I'm a lawyer, and my legal opinion, the presidents have no authority to do any of this, most of this stuff. But presidents walk all over the Constitution and law all the time. So if you're going to be, careless about the law, then let's be careless like this. Just allow U.S. citizen spouses, their spouses, to get a tourist visa, come to the United States, and just file for a green card. So at least they're together, waiting through the process. So that's my opinion on it. There's a hassle of delayed work permits. Once they're here, they're stuck. But that's about it. And with that, I want to thank everyone who joined Matador. Thank you so much for sending some love on TikTok. We'll be back again next Wednesday, Wednesday, 5 p.m. Pacific, taking your immigration questions, general education stuff. In the meantime, download the Marriage Immigration Ultimate Guide at marriageimmigrationlaw.com. And if you want to have a consultation, just email me at info@jqqlaw.com. The email you sent is myself, and I'll get it and I'll answer you if I could see what's going on in your case, describe what the situation is, and we'll take it from there. All right, everyone, until next one, God bless, be safe, and I'll catch you all next week. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.